I think there's another issue which is perhaps just worth touching on, which is, how did all this come about in the first place, and how can it be prevented in future? Because obviously this is a very damaging situation for both the purchasers, but for the country as a whole. And one of the issues which the House Buyers Association has been promoting is the 1090 concept, the build then sell, where the developer finds his own financing and doesn't use the purchaser's money, and in our case walk off with the purchaser's money. And had the 1090 system been in place, we wouldn't be talking to you now. So you ask about next steps. In terms of next steps, we are continuing to work with the Jabatan Insolvency, with Bank Negara, with the state government. We hope that the new MP in Hulu Selangor will be supportive of our efforts, and the House Buyers Association is still very much with us, and we are greatly indebted to them for their advice. I think that in terms of the immediate activity for the group, we should be having a group meeting for all the members at the beginning of May, so that collectively we then decide on what the next steps are. The actual original development was unlawful. Now, what the chairman of the Estates Land Board has done is to say to the liquidator, to the banks, to us, that he will put a freeze on any transactions in the Genting Valley area on the basis that we, the purchasers and the liquidators, have to come up with an agreed plan. That was April 2009. That's a year ago. So far, neither the liquidators nor the banks, or the bank rather, have come up with any proposals. As a group, we have operated on the basis that if other people won't help us, we have to help ourselves. And so a self-help approach is the one that we have been following. In doing that, we came up with a developer who was prepared to purchase 150 acres of the Genting Valley at the same price that the liquidators had already sold 500 acres of the scheme to a 2 ringgit company. In December, I should say that in October 2008, the liquidators sold 500 undeveloped acres of the Genting Valley scheme to a 2 ringgit company. In itself, that was a concern for members because we didn't know what land had actually been sold, and members obviously were concerned that their plot might have been sold either inadvertently or not. The liquidators were not able to provide us, even until today, with details of exactly what was sold, which was a concern. The other concern was that the liquidators sold the 500 acres at 1 ringgit per square foot. Now, that compares with the fact that purchasers paid between 13 and 20 ringgit a square foot between 2000 and 2003. Why should the land be worth only a ringgit a square foot in 2008? We have not been able to understand. So the issue there for us was, what was this sale about? Who was it going to benefit? Why was the land so cheap? And the answer to those questions we do not know. As I say, we found our own developer who was prepared to buy 150 acres, also at 1 ringgit a square foot, but our developer would have rehabilitated all the existing plots at no additional cost to the existing purchasers. If you've paid 100%, you pay nothing more. If you've paid a percentage, then you finish paying up to 100%, but you only pay the original sum. And the developer, our developer, would rehabilitate the plots and complete what the original developer failed to do, and then would have the revenue for that activity would have come from the development of the 150 acres. So there was the revenue stream that our developer was going to use. Now, as a proposal, it seemed to us as a group that this was both commercially sensible and socially desirable. However, the bridging financier in this case has rejected our offer, and we do not comprehend the reasons for that, because the bridging financier would have got exactly the same money as they would have got under the sale to this 2 ringgit company.
What about your legal representation? What do your lawyers say?
Well, they're, I think, as baffled as we are. I mean, there are legal actions which could be taken, but as a group, we are not a wealthy group at all, and the pursuit of the law in the courts costs money. And it may be the case that we have now reached that stage, but we've been very careful not to be involved in court action, simply on the grounds of cost.
And the time I think it will take to settle this through the courts. So we've actually looked at an amicable settlement, so that everyone really, what's really bad about it is that people are dying. Quite a few spouses and members, they're just going, because obviously we're at that age where most people are retired. So what we really want is a settlement that can be quite quick and fair to everyone.
I think one of the key factors about this scheme, as against many abandoned schemes, is that this scheme has assets. 500 acres of undeveloped land, that's an asset, and if handled in the right way, could give the bank all its money that it spent on the original developer, rehabilitate all our plots, and still have something left over. So that the rehabilitation for the existing purchasers is a very feasible and commercially sensible option. Why the liquidators would want to sell it for RM 1 a square foot, I don't know. We have not seen any documentation that the liquidators may have had access to on valuation. Coming back to your question about forced sale. But we don't know what the valuation said. But if it said RM 1 a square foot, I think we'd all be rather surprised. Well, I think the message to the state government is please stick with us. They've been extraordinarily helpful so far, but we've got to bring this thing to a conclusion. And we very much hope that the new MP in Hulu Selangor will be in the lead in that process.
What about add-ons? Have you approached add-ons? Because the add-ons are VN add-ons, isn't it? The state representatives?
Yes. In Batang Kali, the add-on is a BN representative.
But he's been out of action for some time because he was not expelled, what's the word?
Suspended.
Suspended.
Yes. And I think also, that we are trying to help ourselves means that the Selangor state government does not have to put in taxpayers' money towards rehabilitating projects like this. And I think for the future, really, we see that there are loopholes in the law, and so that people don't go through the dilemma and agony that we've been going through for all these years trying to sort this out, and we're no nearer our goal. That people don't go through the same dilemma that we're going through. Obviously, a lot of people are suffering financially, and it's really beyond some of them. So why do we all have to go through this when housing really is a basic right for everyone? And basically the state government has to look into these issues when it comes to housing.
Could I ask who the developer was?
A company called Jade San Realty, Sendiri and Berhad, now with the additional words in liquidation.